Hello, good morning, or afternoon, or evening, depending on when you're watching this. My name is Curtis Polk, and I'm the Employee Ombudsman and Ethics Advisor at the Texas Department of Insurance.
I am Vivian Harvey. I work as a project manager in HR. As well, you probably know, Curtis and I normally teach the sexual harassment and discrimination course for video or for the mandate that is required. So welcome to the video.
Welcome to the video, and as you see, we are recording this during a time of social distancing. Well, at least that's what Vivian tells me. Maybe she just doesn't want to sit next to me. But we're here, and we are glad that you are here. Our class is called Respect in the Workplace. Now, Respect in the Workplace, addressing sexual harassment and discrimination. We have always referred to what we do when we teach this class as Respect in the Workplace because the overall umbrella of what we hope all of us in the workplace do, and that is show respect towards each other. And if we are respectful towards each other, that means that we won't harass or discriminate or do any other kinds of disrespectful activities or behavior towards each other. So overall, it's called Respect in the Workplace. I'll go over the overall goal and the objectives, and if you have the handout, feel free to follow along. The overall goal is that participants will be able to distinguish between appropriate and inappropriate workplace conduct, including sexual harassment, discrimination, and issues of respect and ethics, which may have legal consequences if left unaddressed. The training objectives: through course activities and group discussions, participants will increase awareness of agency policies and procedures related to sexual harassment, discrimination, and sensitive personal information, as well as protected health information. Again, if you're watching this video and you are not an employee of TDI, your policy or your procedure will override what we're talking about. Certainly, the parts of the class that we are discussing with regard to federal laws and state laws and policies, they affect all of us. But your particular state agency rules and regulations will apply only to you, not the rules and regulations of TDI. The second bullet: to be able to apply federal and state EEO laws to workplace situations. And the third, to understand how showing respect to others in the workplace is positive and essential to prevent inappropriate and/or illegal behavior. The course will satisfy the legislative mandate for all state employees to attend protected health information training and sexual harassment and discrimination training every 2 years. The legislature made it mandatory many years ago that all state employees have to attend a sexual harassment and discrimination course every 2 years, and if you are brand new to a state agency, you have to do it within the first 30 days of employment. We are glad that you are watching this. Now, normally, Vivian and I, we do it stand and deliver style, but due to a lot of different reasons, we are doing it through video exclusively, and we are glad that you are with us today.
Well, I just would like for us to talk about the definition of respect, because that's going to play throughout this whole course, and we will wrap up with the term or the definition of respect. So I wanted to quote what the dictionary says. It says, respect is due regard for feelings, wishes, rights, or traditions of others. So if you'll just kind of keep that in mind as we move through the course, you'll see that popping back up, because as Curtis mentioned earlier, that's always been our guiding, I'll call it our guiding light, or our focus as we develop these courses for you every 2 years.
Let's have some quizzes. If you'll turn to the page on quiz number 1. If a person says they did not intend to harass a coworker, does intent have to be considered when determining whether harassment occurred? And the answer to that question would be no. You do not have to intend to harass in order to be found guilty or to have an investigation take place if someone makes a claim that you harassed them. I've never investigated a situation where someone said, yes, I intended to harass them. Intent does not matter. It may matter when a penalty, if assessed, if a penalty is warranted, but intent does not matter. Question number 2, Bill?
Yeah. In a sexual harassment situation, the harasser can be, we know, a manager, be a coworker or a customer to your organization, or there's a couple of blanks there, think about it, a vendor, someone coming in to deliver water or packages, or someone that you're doing business with, like an IT vendor that you're working with, or a temporary employee. So harassers in the workplace can come from many different avenues, so to speak.
Question number 3. As it pertains to overall hostile work environment, which type of sexual harassment is described in this scenario? Your coworker said he got a merit raise. Later, you hear he's in a romantic relationship with your manager. You think the merit raise is linked to the romance and you are upset. What particular type of sexual harassment would this be? And if you said third party, you would be absolutely correct. A third party claim, anybody can file a claim of sexual harassment. A third party, someone who's not involved, they could do that. We'll talk more about third party reporting when we get over to the next page.
The last discussion question there is, what rights does an unpaid intern have if they feel that they're being sexually harassed in the workplace? And the legislature added some verbiage a few years ago to say that they have the same rights as a paid employee does. So in our agency's policy, you can find it there, and sometimes people wonder about unpaid interns and what their rights are. So their rights are just the same as mine and yours.
If you turn over to the next page, I'll go over the specific types of sexual harassment. The first type, as you see at the top of the page, is quid pro quo sexual harassment. As you see, it's where employment decisions or expectations are based on an employee's willingness to grant or deny sexual favors. Look at the examples there. Demanding sexual favors in exchange for a promotion or a raise, disciplining or firing a subordinate who ends a romantic relationship, or changing performance expectations after a subordinate refuses repeated requests for dates. Quid pro quo. This is the type of sexual harassment that they still tend to show in movies and on television because it's more dramatic, it's more titillating. It's a this for that type of sexual harassment. However, in today's workplace, we don't see this type as often as we once did. One reason being what we're doing right now, mandatory training, where everyone learns what is appropriate, what's not, what's harassment, what's not. And so we have, many workplaces don't have a problem with this type of sexual harassment. However, the second one on that page is where a lot of workplaces tend to veer off the path, and that is hostile work environment sexual harassment. As you see, it's where verbal or nonverbal behavior in the workplace focuses on the sexuality of another person or occurs because of that person's gender. It is unwelcome, unwanted, and or uninvited, and it is severe or pervasive enough to affect that person's work environment. All of the cases that I've investigated during my time as the employee ombudsman at the agency have fallen under hostile work environment. Many people know that whole do this or else, or if you do this, then I'll give you a raise. That quid pro quo type of sexual harassment, most people understand that's illegal, that's wrong, that will get you fired in some workplaces right off the bat. But hostile work environment, what exactly is that? And if you look at the examples, you'll see this is where the off-color jokes or teasing come into play. Comments about body parts or sex life, suggestive pictures, posters, calendars, cartoons, leering stares and gestures, excessive attention in the workplace in the form of gifts, telephone calls, love letters, or email, inappropriate email, repeated requests for dates, touching, brushes, pats, hugs, shoulder rubs, pinches. All of these could be considered sexual harassment or improper sexual conduct because they could go to creating or continuing a hostile or intimidating work environment. There are 3 specific types of sexual harassment that fall under hostile work environment, and if you're following along, there they are. The first is same-sex sexual harassment. The fact that a man can be found guilty of sexually harassing another man, a woman can be found guilty of sexually harassing another woman. It makes no difference about gender or sexual orientation. People harass people. The second there is non-employee sexual harassment. Non-employee sexual harassment is where someone comes into your workplace to deliver a package or to conduct business in your place of employment, and they say or do something to you that they ought not say or do. The law protects us from people coming into our workplace saying or doing something inappropriate. But the law also protects those people from us. We cannot say or do something to a visitor who comes into our workplace. They are non-employees to us. They are protected by the same policy. And the third, there at the bottom, is third-party sexual harassment. And we briefly touched on that in the previous page. Third-party sexual harassment is where someone who saw something, they could make the claim of sexual harassment. If they found out that you were dating the manager, or if they found out that someone did something to you, but that person chooses not to make the complaint, you could make the complaint for them. Third-party sexual harassment. At the bottom of the page, what's the difference between sexual harassment and improper sexual conduct? Sometimes I will interchange the terms. I'll say sexual harassment. I'll also say improper sexual conduct. And the reason being, sexual harassment is federal law. But sometimes things happen in workplaces that may not rise to the level of being against the law, but they are still inappropriate. They're still disrespectful in nature. So the investigation could show that while it did not violate federal law, it's still inappropriate for the workplace. So that's why I will interchange those two phrases. If you turn over to the next page, we'll talk about the policy as well as the stages of what happens when at TDI an investigation begins to take place. At the top of the page, the question asks, as a non-employee TDI, what is your responsibility in reporting sexual harassment? As a non-management TDI employee, what is your responsibility in reporting sexual harassment? TDI urges employees, all employees, to report things and bring it to the attention of management. We want you to report it. There is no policy that says that you have to, but we strongly urge the reporting of the situation. Who would you report it to? You can report it to your manager. You can report it to any TDI manager, anyone who's not in your chain of command even, as well as the agency policy says that you can report it to the HR director, the employee ombudsman, or either commissioner, the commissioner for DWC as well as the commissioner for the insurance side of the house. As a manager, if an employee reports sexual harassment to you, what should you do? If you are a manager and someone reports it to you, you have an obligation as a manager to do something about it, to report it to someone who can start the investigation. You could begin the investigation. As a manager, you have a legal responsibility to address the issue. Unlike non-management employees, we strongly urge you to report it. Managers have an obligation to do so. Now, if you're following along, we're now going to talk about the stages of a sexual harassment complaint when it happens here at TDI.
I think we often talk about the policy, but we don't talk about the process. And so if you're interested in the process, Curtis has already talked about who can you report a complaint to. So we know that if you're an employee that feels like they have, they either saw something, they think that there is an issue, they have a concern, or they want to file a complaint, they can file it with Curtis, HR director, either commissioner, their manager, any TDI manager. You've heard him talk through those. So if they didn't file it directly with him, those other persons would give Curtis that complaint to investigate. Once he investigated, he goes back to the HR director and legal counsel and reports what he found. And then the HR director and legal counsel come up with a recommendation. They're going to look for consistency in the organization. If this has happened before, what was the result? What was the solution that we came up with? What was the recommendation? And they're going to give that recommendation to the chief of staff here at the agency. And then they're also going to give that recommendation to the deputy who's in the chain of command where the issue took place. Now, then HR is charged with putting things in motion in order to, I'll call it, fix the situation, in order to remedy the situation. And one important part is a few weeks after they put in place the action plan, they will check back in with the division to see whether their solution or recommendation has alleviated the situation. You know, so many times we think that we have fixed something. I'll just use that term, fix something, and then you check back in, and you realize you really didn't fix it. Something else popped up, or you need to go back and revisit your solution or your recommendation. So HR will circle back around and make sure that that has happened and that the issue was resolved. Now, the next thing that we want to talk about is the consequences of sexual harassment. Big picture. Well, let's talk about little picture first. Macro, from a macro standpoint, yes, there's going to be an investigation. People are going to be talking. There'll be workplace disruption. But at a macro level, from a big picture perspective, what happens to an organization that is either going through sexual harassment complaints, or the agency is becomes I'm just going to use the term infected with sexual harassment. You know that if people are talking, the productivity is going to be going down, the morale will go down, the attrition, us losing employees, is going to go up, and you know, you can't keep things like this under wraps. It will be harder to find employees who want to work for an organization like that, because the agency's reputation is damaged in the end. So we need to think about, we often think about what happens in the workplace, you know, between coworkers. But big picture, the organization is affected too. There are lots of consequences in the organization. Now there's some, we'll call them case studies, but there's some examples of sexual harassment, and I want to go over the very first one. Last year, Sally's team lead pestered her with an inappropriate remarks and even touching. It stopped for a while, but lately he's been at it again. Sally doesn't want to wait to see if it will stop this time. However, she's worried if she reports it, people are going to say, why now? Why didn't you report it before? Now, I think this kind of gets to a lot of what we saw in the Me Too movement. You know, there were a lot of us that were saying, why now? It's been 10 or 11 years. But if you were Sally's friend, what would you advise Sally? What could you encourage her to do? Or would you encourage her to do? I think you would probably encourage her to file a complaint. If it happened before and it stopped, but it started again, that doesn't mean that she can't also talk about when it happened before. But it's happening now. She needs to she needs to file a complaint and start some sort of remedy to her situation. And in fact, there may be other employees that the team lead is harassing, and she's not aware of that. So let's say, in the past, the team lead has harassed other people in addition to her. So, and has we'll call it a serial harasser. So, those patterns as an individual, you may not know about, but if you report it, then someone else may know about the pattern. Now, some of you may ask, is there a time limit on when Sally can file a sexual harassment complaint with the agency? Is there a statute of limitations, so to speak, within an agency for filing a complaint? And the answer to that is no. That complaints can still go to the employee ombudsman or to HR or to any of those management or commissioners, as we talked about earlier. While it might have been best for Sally to report it before, there are lots of reasons why she might not have reported it. And so reporting it now is going to be essential for her. Curtis, you want to do the next one?
I'll do case study number 2. Doug walked to a workplace cubicle that Angie and Deborah share. He stops by every day to say hello. When he dropped in, he saw Angie and Deborah watching a music video that showed performers in various stages of undress. He clearly saw men and women dancing provocatively, and at least one woman was partially nude. Though he was embarrassed about what he saw, he still said hello, but he didn't stay and talk to them like he usually did. Now, question. Can and or should Doug file a sexual harassment complaint against Angie and Deborah? Are they doing anything against agency policy? Can he? Yes, he can. Should he? Well, it depends. Some employees would say, well, depending on his relationship with Angie and Deborah, if he's pretty close to them, he could just say, y'all shouldn't be watching this at work. This is inappropriate. We live in an age of music videos and TikTok and things like that. So sometimes people watch things at work they should not watch, and you are taking a risk because if you have a coworker come by and see it, they could report it without talking to you. They could just report it. So again, could he do it? Certainly. Would you, if you have a good relationship with your colleagues? That's something that you would have to decide. And that goes right into the second question, what options does Doug have? Well, again, he could just say, y'all need to stop watching this video. This is inappropriate for the workplace. Or he could report it to a manager. He could report it to the employee ombudsman, me, if we're talking about TDI. Or he could report it to any manager. He could report it to the commissioner. So again, there are things that he could do, starting off with talking to his colleagues about what's appropriate, what's respectful, if you would, behavior here in the workplace. Let's turn over to the next page, and Vivian will start talking about discrimination in the workplace.
As we start moving into the discrimination portion of this course, I want to ask you a few questions, like a little quiz before we get started to see how much you remember about discrimination. The first question I have is, what are the 7 protected classes that are covered under this discrimination law? That is, protected classes, I mean like categories. And so right now you're thinking, okay, which ones? National origin or ethnicity, race, color, and remember color is lightness and darkness of the skin. Religion, gender, or some people call it sex, age, and disability. So there are your 7. Google paid out $11 million in a class action suit in 2019. Before that, in age discrimination, and before that, Texas Roadhouse had some of the similar issues where applicants were denied jobs into Google or Texas Roadhouse because of their age. So we still see lawsuits forming under all of these. Race, under the category of race. Tesla paid out $137 million in October of 21 under a race discrimination claim. If you don't know about that, look it up because it's interesting. And so these things still exist. They still have problems, even large organizations or small organizations. Now, these are the 7 protected classes, and we're going to go into each of the laws that initiated these classes in a few minutes.
I'll take question number 2. Which theory of employment discrimination focuses on the impact a workplace policy has on a group of individuals in a protected class? And the answer is inside your handout, and Vivian will talk more about it, but the answer is disparate impact. Disparate impact as opposed to disparate treatment. And Vivian will talk a little bit more about that when she gets over to that page. But the answer to this is disparate impact.
Leave it up to me.
Yes, because you have to talk about it all.
Okay, the last one I wanted to mention was sometimes employees of an organization, they want to go file a discrimination charge outside of the organization, and sometimes they go to EEOC. And I've kind of watched the lawsuits that go, or the claims, I think that's the term, the claims that go to EEOC since 2017. And each year the retaliation number, the number of claims under the retaliation category increase. And they increase again in 2020, and I expect, next month the 2021 figures will be out, and I expect it should increase again. What's interesting to me, 56% of the claims that go to EEOC are retaliation. They're not age, race, religion, color, any of those 7. Now we know that when people go to EEOC, they could file a claim under more than one category. They could say you discriminated against me based upon my age or my color, and they also could say you retaliated against me because of something. But the EEOC reported a decrease in the number of actual discrimination claims that came to them from 2017 through 2021, which I think is interesting, that the number of retaliation claims of the ones that went, even though they went down in number overall for claims, retaliation was still climbing as the number one claim in the mix. Now let's talk about those anti-discrimination laws I just want to say individually, maybe that's it. The very first one we all know, Title VII, Civil Rights Act of 1964, it kind of started the ball rolling with 5 protected classes. We just mentioned in the quiz before, the race, color, national origin, religion, and gender. So of those 7, the first 5 were laid out in that particular law. One of the things that's happened since the last time we did a video was the definition of gender or sex covered under this law has changed. So now the courts have decided that this discrimination is based on sex, including sexual orientation and gender identity. With the Supreme Court case that came out, it's a landmark decision, Bostock versus Clayton County. So I want to spend a few minutes talking about that. When the Supreme Court made this landmark decision in 2020, they used, or the title of it is Bostock versus Clayton County, Georgia. But they also pulled in or reached out to pull in 2 cases that did make it to the Supreme Court, but were very similar. So the Supreme Court has determined in this landmark, their landmark decision, an employer who files an individual based on their sexual orientation or gender identity violates Title VII of the Civil Rights Act of 1964 based on gender or sex. So they encompassed the sexual orientation or gender identity in that particular category or that particular protected class. Now, I mentioned that they reached out for 2 more cases and brought them into the decision that they made. So Gerald Bostock was, he worked for Clayton County, Georgia, and he was fired for, as they called it, conduct unbecoming a county employee shortly after he began participating in a gay softball league. Also, they reached out for 2 more, and one of them was Altitude Express. They were fly diving, whatever you call, where they jump out of airplanes, so you can get it, Altitude Express, right? Altitude Express fired Donald Zarda, who was their employee days after he mentioned that he was gay, and Harris Funeral Homes fired Amy Stevens. Amy presented herself, or she started working for the funeral home, presenting herself as male. Then she told her manager somewhere after 2 years that she was going on vacation, and when she came back off of vacation, she was going to live and work full-time as a woman, and he immediately fired her. Now, each of these employees sued, alleging sex or gender discrimination under the Title VII of the Civil Rights Act of 1964. So that is a biggie for the Supreme Court since the last time we were together. The other anti-discrimination laws, we have age discrimination. We mentioned Google a few minutes ago, age discrimination, and that is people are protected after they're 40 or over. Equal Pay Act of 1963, even before 1964 Civil Rights Act, the courts realized that men and women were not paid the same. You might see more publicity about Equal Pay Act or equal pay between men and women, particularly during a political debate. The Americans with Disability Act of 1990, and 19 years later, an amendment to that, ADA law. So it covers anyone who has a physical or mental impairment, have a record of an impairment, or they're regarded as having an impairment, such as someone who may not be impaired, but they are regarded, someone maybe who was scarred from an accident or something like that. That might be an example. And the last one we need to talk about is Genetic Information Non-Discrimination Act. The easy word for this is GINA, Genetic Information Non-Discrimination Act. And I can already tell you that we as an organization, we as a state agency are not going to discriminate against you because of the genetic information or because you refuse to give us genetic information. So those are the anti-discrimination laws that are federal laws. There's Texas Labor Code also lays out the same 7 protected classes. It mirrors the federal government. And Texas law also covers the Whistleblower Act, which we've talked about many times in these classes. Remember, if you want to file a whistleblower complaint, you need to do it in good faith. It has to be a violation of law, so you have to make sure that it's illegal, and you have to report it to the appropriate law enforcement authority. You may not know who that is, but we have lots of peace officers or law-related employees. If you don't feel comfortable talking to them, there may be someone in your neighborhood to find out who the appropriate law enforcement authority is, so that you could file a whistleblower claim. Now, Curtis mentioned a few minutes ago that I was going to talk about the theories for determining employment discrimination. Basically, any type of discrimination is going to fall into 2 categories. One is disparate treatment, the other is disparate impact. We frequently see disparate treatment, but we less frequently see disparate impact. Disparate treatment is when I treat you as an individual different because of your race, your color, your religion, your age, any of those 7 protected classes. The second piece that we see less frequently is disparate impact, where a group of individuals in that age category, a group of individuals in the race category, religious category, are impacted, that's the reason it's disparate impact, are impacted different based upon a policy or a practice in an organization. So, if you had a downsizing of an organization, several years ago when the economy was in the tank, there were lots of downsizing organizations, and they would lay off mid-level management. Well, mid-level management a lot of times just happens to be 40 and over. So they would file class action lawsuits based upon age because they, as a group, were treated or were impacted different because of that practice or that policy. So you can kind of see the difference there. They're pretty similar, but one of them has to do with an individual, the other one a group. So they're not the same thing. If we talk about, wrap up with the quiz, we were talking about things being similar but not the same. Let's talk about other 2 similarities. Sensitive personal information and personal health information. See, I just changed gears on you, didn't I? So, sensitive personal information is treated in our organization, in our agency, and in your workplace different from the personal health information. right? And rightfully so. The personal health information is confidential. It might be things like medical records of you. It might be your benefits file that HR has, or doctor's evaluation for injured workers. So that health information of you, health information of your clients or the people that you work with as part of your job, those sorts of things are health related and personally health related and are confidential. The other things are not confidential, but they're very sensitive in nature. It could be your home address. It could be your family member's name, the names of your kids. It could be credit card numbers, social security numbers, dates of birth, things like that that you come across in your job. Even computer passwords. Sometimes we think, they are sensitive, but sometimes we write them down when we get a new password and we may not throw it away too quickly. So those are sensitive also. So that's the difference, the similarity, but the difference between sensitive personal information and protected health information. I want to take the next one?
I'll take the next two, as a matter of fact.
Well.
Question number 2. In the Employee Conduct and Ethics section of the agency's policy manual, it states, it is very important that employees of TDI avoid the appearance of impropriety. Now, from a practical perspective, what does this mean? The appearance of impropriety. As your ethics advisor here at the agency, I get an opportunity to help managers and employees deal with ethical situations all the time. And basically, the appearance of impropriety states that if something appears to be improper, it is improper, therefore, don't do it. In essence, we need to be above board when it comes to ethical behavior. All of our behavior at the agency, whether it's dealing with personal insurance matters or matters related to the agency, we all must be above board when it comes to ethical behavior, because ethics is all about should, not can or could something happen, but what should happen. And we should all strive to be ethical in the workplace. And that leads us directly into the last question for today. What are some examples of respect that you see in the workplace that make it a better place to work? I started off by talking about, we call this course Respect in the Workplace, rather than just sexual harassment and discrimination. Because if the overall umbrella is that we need to be more respectful of each other, that means that we won't harass each other. We won't discriminate against each other. But also it goes deeper than that. It's showing respect towards your colleagues, not taking things from the refrigerator that doesn't belong to you, helping your colleagues with tasks and things that they have to do when they need assistance. Being a role model for coworkers. Not just managers being role models for non-managers, but everyone can be a role model in the workplace. So basically, it's treating each other with the same level of respect that you yourself would require. And that's not harassing, not discriminating, but also being ethically above board and helping coworkers when they need assistance or help. Basically, treating people like you would want to be treated. That's the essence of respect. And that's what we try to accomplish every day here at TDI. Now, you have an acknowledgement form that came along with you watching this video. I'm sure HR would love for you to sign that acknowledgement form, acknowledging that you viewed the video and that you will send the form back so that it can be placed in your personnel file. Vivian and I thank you for watching the video. And if you need any assistance, feel free to contact Vivian in HR, or as your employee ombudsman and ethics advisor, feel free to contact me.
Thank you for being with us today. We wish that we could see you in person, but video is the way that it's a sign of the times now, and we appreciate the fact that we're able to continue to do sexual harassment and discrimination training for the agency, as we have done for a number of years.